2 of what was too long of a 5122. Hang on. I think I just get that back. There we go. Hang on. Wrong thing. Let me top. I don't know why I didn't open it for you. Wait a second here. Ah, there we go. And I did upload this to the iEcho site just now, so you have that. I think that's why it faded in the background, actually. Anyway, can you see the screen? Okay, thank you. So last time, several weeks ago, we talked about the Pinkslip, the initial piece, and I'll just real quickly reiterate, the Pinkslip is officially the application for emergency admission. I think it's a misnomer, and in fact, OMAS may change it to the application for emergency examination. That's really what it is, because 70% of the time people taken in on a Pinkslip, usually by first responders, they actually don't get admitted. They do, however, always get the examination. So the Pinkslip is the examination up to 24 hours to do that examination, and then to make one simple, I'm kidding, of course, not that simple necessarily decision, either send the person home, whatever home is, or admit them voluntarily if the person at that point realizes they really do need help, or to admit involuntarily. And that's the path we're going to continue on today. Is I always say Mr. Jones to make it simple, but it could be Ms. Johnson, whoever he, she, or they are that are being the subject of the Pinkslip. So the person has now had a Pinkslip done under this model. And again, no disclosure, same thanks to the various people that I work with around this. Judge Stormer, phenomenal, had been on the criminal court, shifted over over a decade ago now to the probate court, and has been truly a national leader in probate law at this point. And that's, feather in the cap of Summit County and Northeast Ohio to have her still on the bench. Betsy Johnson, who used to be with NAMI Ohio and then shifted to the Treatment Advocacy Center as the regional representative, which includes Ohio. And then Christina Shanak Diaz, who's at OWACPA, which is all the ADM boards, Mental Health Recovery Service Board, same thing around the state. So we've talked about this. So we're going to go with Mr. Jones, had a Pinkslip, involuntary. We think he needs to go to the hospital against his will. He likely, most commonly, because he does not have insight. He doesn't realize how ill he is. And so as a result of that, we move him to the next level and we say, okay, we're going to have you end up in a hospital setting. So examination or evaluation was done in Summit County. That would be in an emergency department or psychiatric emergency services. Now we go over here to the involuntary admission. What happens at that point is a new clock starts. And I think that's really important for this 3-part series to understand these various timeframes. So the Pinkslip was up to 24 hours. And once the decision was made to admit Mr. Jones, the Pinkslip has done its job. The time is over. So if that happens in 6 hours, the Pinkslip's done its job. Let's say, though, it takes 20 hours after that to get the person into a psychiatric bed. So now you've got 26 hours. That is not illegal. And I want to be clear about that. That 24 hours was the Pinkslip. When you acted on the Pinkslip, and on the back of the form, they wrote the disposition, awaiting bed at Summa or Cleveland Clinic or, another part of the state, a different hospital. The Pinkslip's done. Now because at that point, imagine, if you will, that Mr. Jones is that ill. You've said he needs to go to the hospital against his will, and you're like, well, it's 24 hours exactly. I guess we'll have to release him now. That would not be a good clinical or legal decision to release him when you've just documented why he needs to stay and go to a hospital. So just understand that gets confusing, I think, all over the state. So the Pinkslip was done at the 6-hour mark, basically. Then you're in this window of waiting for a bed. Once Mr. Jones ends up in a psychiatric hospital, at that point, a new clock has started. And that clock is 3 court days, not 72 hours. You'll hear that said a lot. It is not 72 hours. It's 3 court days. So imagine, if you will, we just had recently the President's Day weekend. So let's pretend that Mr. Jones, you did a Pinkslip at noon on I'm sorry, you ended up in the hospital at noon on today, noon on a Friday. Before that, well, wouldn't I think what the 16th or something. So on noon on the 16th. So Saturday at noon, Sunday at noon, and Monday at noon do not count. Tuesday at noon is the first court day, which by my math is a lot of days. All right. So just be aware of that. There's that those weekends don't count, and holidays, court holidays, which are most of the major holidays, do not count in this equation. So it's 3 court days. Now, I put a little caveat here. Let's say that Mr. Jones is in the hospital for a day or two, and he says, wow, I'm feeling a little better, and I do realize I have a mental illness, and I really need help. I'll stay voluntarily. Well, you could then, that's up to the clinicians on that unit, you could allow him to sign a voluntary, which would, of course, eliminate the 3 court day issue, and you would basically treat him until you and he agree that he's safe for discharge. So that can also change here in the equation at any point. Let's play it the other direction. Let's say he had been at PES or an ED and went into the hospital voluntarily, and he's working with you, but it turns out it's kind of superficially working with you. Like he'll stay, but only if you give him stimulants and benzodiazepines, which happens, right? And you're like, that's not the treatment for your illness. You need this, that, or the other thing, an antidepressant, a mood stabilizer, antipsychotic, even whatever it is. And you're at odds, and it's clear he really doesn't have insight, meaning he really can't consent or even assent to staying in the hospital. You could then do an affidavit so that he has to stay in the hospital against his will. So you're allowed to do that. If he puts in, the other option is if he puts in a notice, so-called 3-day notice, that says, you know what, I know I'm voluntary, but I want to leave. The clock again starts, so you've got 3 court days to figure out whether or not you're going to let him stay or not. Right. So you get time to examine him. The examination is the word in the law, not evaluation. You get time to examine him and make a determination. So if you make a determination under any of these scenarios that he needs to stay longer, then you do this affidavit of mental illness, which looks a lot like the Pinkslip, although it has more detail because, as you know, you've now observed this person for at least 3 court days, which might be, Monday through Thursday. But if it happens to fall later in the week, you might actually have had a day or two extra there, well, 2 days or 3 days extra on the weekend, depending on where that falls. So you do that paperwork. That paperwork goes to the court. Meanwhile, obviously, continue your treatment as you're allowed. And the court now, once they receive the paperwork, has their own clock, and that clock is 5 court days within which to hold a hearing to determine civil commitment or release, because that will happen. If they say no, he's released forthwith at that hearing. So you need to know that too. If you're in the inpatient side, if it doesn't go your way, if your opinion is that this person, he, she, or they needs to stay, and the magistrates, usually it's a magistrate in that setting, says no, he's out, she's out, they're out. So just be prepared for that. I've not seen it many times in my, I think, 26 years now in Ohio, but I have seen it happen. And that causes all sorts of consternation and running around for the next hour because, of course, they do give you a little bit of time to effect a discharge, but it's not a lot, because now you're impinging on somebody's freedom and the court says you can't. So just be aware of that if it happens. Now, I will say there is another caveat in the law. Let's say that the storm hits and the power goes out the day of the hearing and they can't hold the hearing. The court, by the stroke of the gavel there, that's good to be judged, as they say, can extend that another 5 court days, meaning the person stays in the hospital and awaits their fair hearing 5 days later, which usually translates to about a week. In Summit County, I can tell you that has never happened as far as I'm aware, because every Thursday morning, like clockwork, the probate court has these hearings, except on Thanksgiving week. They have it on Wednesday, of course, before the holiday. And what they do, and I'm saying this may be different in other counties, and I know a number of counties are represented here today, but the example here is that, but this is illustrative of what happens. So Mr. Jones at this point has all of the 14th Amendment due process rights that you would expect. So he gets a notice of the hearing so that he can understand what's going to happen. He is allowed to therefore procure witnesses if he would like to have witnesses at the hearing on his behalf. He's certainly allowed to take the stand on his behalf. He is assigned a public defender attorney. However, he can hire an outside counsel if he prefers. But generally, honestly, I wouldn't recommend that. I wouldn't recommend that to my own family member because these attorneys, they are very good at these hearings. Most attorneys, unless they've done that in the past, have no idea what to do in a civil commitment hearing. I don't care how highly paid they are. It's just not their forte. So they are assigned a public defender, and then that public defender will meet with the patient either the Wednesday night before the hearing or oftentimes very early Thursday morning right before the hearing, have a discussion with the patient. Again, I'll say Mr. Jones for ease of discussion. And Mr. Jones, what's your interest? And Mr. Jones, you know what? I want out of here, right? That's usually what the patient's going to say. And please remember then that the attorney's role, the public defender's role, is to zealously represent the wishes of the person, even if those wishes are psychotic. So if it's clear to the attorney that Mr. Jones is really ill, and often it is true because that's why you're going to have a hearing, they still come into court and will zealously represent his desire to leave. And I want you to understand that. So if you ever watch one of these hearings, you may be like, doesn't the attorney see how ill this person is? Well, yeah, they do, but their job is to defend this person's liberty interest, which is to leave. So just be aware of that as well. Obviously, if there's a public defender, there's also an attorney representing the clinician side, saying we think he needs to stay. So in Summit County, we have an attorney. His name is Barry Ward. He's been doing it for decades. He does other law stuff, but he's very good at this as well. So he will represent, in effect, the ADM board at every hearing. And why is that? That's because under the Ohio law, when somebody is civilly committed, they are not committed to the hospital. So let's say he went to SUMA or Cleveland Clinic, even in Cleveland itself, that he's not committed to the Cleveland Clinic or to SUMA. He's actually committed to the Summit County ADM board, if we're talking about SUMA, usually at least, or in Cleveland, it would be the Cuyahoga board. So and obviously any other board around the state. So and the reason for that is that ultimately the boards, and that really means the chief clinical officer. So in Summit County's case, that's actually me. We are required to track all of this, make sure that the right things are happening for the patient, make sure that the hearings occur. Obviously, that's heavily involved with the probate court, who controls a lot of those levers, as well as the agency that may see the person upon discharge. I'll get to that, how that's different in Summit County. But ultimately, when people are discharged from the hospital, certainly they need to be connected and ideally a warm handoff to whatever agency is going to see them, ideally within a week. Well, ideally within days, but certainly within a week of discharge from our highest level of care that we have to offer in Ohio. So again, you have the hearing, and there's, by the way, in the room is also a court reporter. So they do take, stenographer does take their version of notes. Obviously, a whole other language that they have to learn to take the notes the way they do it as a stenographer, and the magistrate. And how does this work in Summit County? I believe this is true for many counties. That team actually travels to the hospitals. They do not make clinicians and psychiatrists and others, and the patients themselves, of course, get up early in the morning and then drive down to some judge's chambers and have hearings. That would definitely take up a lot of time that could be used for treatment, and of course could be used for treatment of other people who aren't going to the hearing that day. So in Summit County, very friendly approach. The court travels to the hospitals. So on a given Thursday, such as yesterday, they started at North Coast. That's always the case. Almost always North Coast has at least one person set for a hearing for Summit County, just given the nature of who would go to North Coast and the level of illness. So they start at North Coast. Obviously, they won't if there's nobody there, but they start at North Coast. And they've already had the notice of the hearing, all those due process rights. Also helps the system work better, not just to protect the patient's rights. And so the person, they descend upon North Coast in the morning. Right now, the law allows only the psychiatrist. Well, they not only, but has to be the psychiatrist who testifies. That could get changed to add psychiatric nurse practitioners, which I think is literally just an oversight in how the law was updated. Since they are on the pink slip now officially, it's logical that they would also be able to do treatment and testify, especially in the outpatient arena, which I'll get to a little bit later here. That's actually in the third talk. So Mr. Jones is in the hearing. There is a magistrate who calls the court to order. You've got his attorney sitting with him. You've got Barry Ward representing the ADM board. Again, not a prosecutor. Remember, this is a civil hearing, but he is representing the ADM board and really, in effect, the clinician, and particularly the psychiatrist, whoever he, she, or they are, or who they're representing. They're going to see, if they're going to know in advance, does Mr. Jones have any witnesses to call? Pretty rare, but it happens. And then they go through the actual hearing. It's a very serious court matter, and there's generally a room at each of the hospitals where they use this as court. It will not look as formal as a courtroom, of course, but they can make this work and make it formal enough so it's understandable to the patient, and most importantly, of what's going on, why are we here? They go through the motions. Let's say, again, for the sake of argument, that Mr. Jones is very ill and the magistrate is in agreement with the testimony on the side of, yes, he needs to stay. Again, usually by the psychiatrist, maybe others. So at that point, the magistrate will say something like, I find by clear and convincing evidence that Mr. Jones, is a mentally ill individual subject to hospitalization and a bunch of other language. And then it'll end with the phrase for up to 90 days, which makes, honestly, the patient very nervous when they hear 90 days, even though they've, I'm sure, been apprised of that by their attorney. And of course, it makes family members happy. And why do I say that? I say that because nowadays we don't have any families complaining that their loved one was being kept too long in the psych hospital. We have them complaining that they're going to be let out too quickly, a reverse of what it used to be several decades ago. And the patient, of course, is still ill and wants out. So you have this, just to be aware that the hearing doesn't end the angst. It really starts some new angst for the individual, understandably. If you told me that too, that I might stay out from up to 90 days, that would be quite an imposition, right? So you just please understand that from an empathy, sympathy point of view, when you have an individual like this who ends up being told they could stay there for up to 90 days. In practice, it's probably only going to be, let's say, 10 days, even if they're very ill. Remember, they've now been under observation for at least 24 hours, plus 3 court days, plus 5 more court days potentially, right? They've been in the hospital for a period of time. So the likelihood is maybe another 10 days for that time frame. So just so you're aware of that. So let me mention this other piece here, treatment over objection, as part of this process. Summit County, again, does this in an expeditious way while protecting the person's rights. So separately from the civil commitment hearing, but it must happen after the civil commitment hearing, there's paperwork being done in the background, and it's very restrictive. Ohio, by my reading at least, is one of the most restrictive states in the nation around treatment over objection, which is the nice phrase for forced medication. Excuse me. So why do I say that? Well, some states use a model where they allow several clinicians, at least one being a physician, in some cases, I think it's all physicians, who give an opinion that Mr. Jones is that ill and needs to stay against his will. And, well, that's usually the court piece, sorry, but needs to have medication against his will. And that stands. They can document that, and that goes forward. There are other states where the attending psychiatrist gives that opinion. That opinion is taken to a courtroom, and then only the judge or magistrate can make that decision, ultimately signed by a judge if a magistrate does it. Ohio does and requires both. So I'll give you an example. I'll use Cleveland Clinic, Akron General, just since I already used SUMA. So at Cleveland Clinic, Akron General, if Mr. Jones is felt to be too ill to decide to take or not take, that's the ethical approach. So he is so ill Usually it's that he lacks insight, that fancy word anosognosia. He's so ill, he really can't decide to take or not take the medication because he doesn't believe he's ill. So just please understand that's the ethical approach. It's not, oh, we won't take meds, take him to court. It should be, he can't make a logical, rational decision because if he doesn't believe he's ill, there's no way to make that decision, right? If I told any of you, I'll use a farcical idea, that your left pinky has cancer, and then I need to treat that with high dose chemotherapy that'll cause a bunch of side effects, you're never going to take those meds without somebody forcing them on you unless you believe your left pinky has cancer, right? Which again, farcical. But the point of that is, this is not they're in denial. This is beyond that. Their brain does not understand that it itself is ill. If right now I asked you to think about your left foot, you can do that. You weren't until I said it, unless you happen to have pain or something there already. You can think about your left foot. If I now ask you to think about your left temporal lobe, anybody tell me how their left temporal lobe's doing? So you can't do that is the point. The brain does not have good senses about itself, right? In fact, internally it has no sensation. It's only the outer layers that have the nerve endings. So understand that this is different than denial. This is the brain itself cannot sense its own temporal lobe, or most likely in mental illness, frontal lobe. And there's some theory now around cerebellum even being involved in some of this. So that's the piece that I hope you take away from that component of this. So Mr. Jones in Summit County would have the attending psychiatrist write a specific note in the chart that indicates most likely he lacks insight and therefore requires treatment over objection. A second psychiatrist then in that same setting also has to evaluate the patient in person, not by reading the chart. And they also have to give that same opinion. And then it goes to the chair of the Department of Psychiatry or designee if they're out on vacation that day. And they have to review all the notes. Now, they don't have to see the patient. They have to review all the notes, make sure everything's appropriate, and they sign it. And then it comes to me as the chief clinical officer, and I have to review all the notes and ultimately indicate that all the T's have been crossed and the I's have been dotted, basically. Only then does it go to the court, and then the judge has to make the decision. So you see that this is a very restrictive approach. And the reason for that is when you look at society, again, all of us are interested in, are very expert at mental illness and the like, at least as much as science allows us to be experts at that. The public isn't, and the public sees forcing somebody down and sticking an injection of a brain-changing medication on them as worse than putting them in prison. That is what the public sees. So we do this very, very carefully nationally, but particularly in Ohio, we are very restrictive. So it's a small percentage of people who get through this lengthy process, because very few make it to civil commitment hearings. It's an even smaller percentage who end up getting this treatment over objection. So that's just another piece of it. So in Summit County, we do that back to back. So you'll hear the magistrate do the civil commitment hearing, end with for up to 90 days. Then they will end, that'll be over. And then several seconds later, you hear almost as though there wasn't a previous hearing. We are now hearing the matter of Mr. Jones, treatment over objection. And then that information occurs, the testimony. And of course, we've got the record reflects that all these opinions have been given. Ultimately, because of that level of opinion, almost always the magistrate is going to agree Mr. Jones doesn't understand he's ill and he needs to take the medications against his will. The good news is that very few patients, even at North Coast, at least for the years I was there, very few would fight over that shot. If it happened, it would happen once they realize that 6 or 7 staff are going to be there and they're going to end up getting the shot. They don't fight after that, because that obviously feels very barbaric, even to me as a forensic psychiatrist. And as a result of that, by the way, it's very rare. I'm not sure if any states are doing this with any regularity, to, even though these orders follow people in the community, both the civil commitment order, and that'll be in the next lecture, and the treatment over objection order, people are not holding people down at the outpatient clinic and giving them shots against their will. That is just not seen as an appropriate approach to the world. So here's a few of the 3-day period requirements. I've mostly said these out loud, but just you'll see the slide set. But just to give you a sense of this, reiterating the court days, reiterating that this 3 court days really is a solid time frame. So if you hit that third, you can't submit the affidavit late. You must release the person at that point. So that those things are taken very, very seriously here. Here's the other reason that people are civilly committed and or connected to the ADM boards, because the person may need to be shifted to another hospital. Let's say they end up at Summa, but they're way too violent. They really need a more restrictive setting. Well, in Ohio, that safety net are the state hospitals. So in our case, the regional psychiatric hospital is North Coast. So they would be reaching out to North Coast. And North Coast, and this has happened at least once in my time down here at Summit County, may say, you know what, based on what you're telling us, he's too ill for us, and we need him to go to Moritz, which is the maximum security psychiatric hospital in Columbus on the same campus as Twin Valley Behavioral Health Care. So that can happen, and you do not need another Pinkslip, et cetera, during this window. So you need to be aware sometimes these things happen. It's pretty rare, but when it happens, it is allowed to happen. The ADM board's involved, the probate court, of course, is involved, the hospital's involved to make sure that happens. And a new pink slip is not required to make that occur. Again, affidavits, as I said, it looks a lot like the pink slip, which stops here. Let me mention here this piece. So about a decade ago in Ohio, the law was changed, 5122 Ohio Revised Code, which again, you can pull that up for free on the web if you're interested and or are unable to sleep tonight. Pull that right up. Here's one of the sections here that we're looking at. And so the issue is that we found that some individuals were very ill in the community, but they weren't quite at the level to be hospitalized, but yet the parents or others were concerned. The treatment professionals might have been concerned. They're allowed, based on that new law, to do what gets often referred to as the 5th criterion, which is going to maybe change when we possibly change the pink slip, which I'll mention in a minute here. But so this one has some very specific criteria. So these are very ill individuals, right? So you've got at least twice within 36 months, so 3 years. They've had to go through this before, basically. You've got other types of issues with violence and threats for 48 months. These are drawn from New York law, mainly because the attorney who helped us with this through Treatment Advocacy Center used to work in New York and helped write that law. So this was the language that was put in. It's probably been a little bit unwieldy, honestly, because we don't always know this exact data about an individual, because they may jump from treatment agency to another treatment agency and so forth. But the point of this is that the family member or any of you as a clinician could go to the probate court before they're in the hospital, do the affidavits, and then every place will have a process for this. And the person will get evaluated in the outpatient arena, maybe not even at PES or NED, to determine how ill are they and do they meet criteria. If they meet criteria, they can be placed on outpatient commitment, or the national term now, assisted outpatient treatment, without being hospitalized. What a great idea. Why are we waiting till they're so ill that they meet one of these top 4 criteria, especially if it's suicidal or homicidal and may have hurt somebody, which is, again, the first lecture you can refer back to on the Neomed YouTube channel. So that's the purpose of this. In practice, interestingly, what has happened, because families get used to individuals' illness levels and behavior, is I think now about once a year, this has been tested in Summit County, every single time that the evaluators that for us come out of Portage Path, they are in the psychiatric emergency services center there, but they go out to the person's home, usually a residence, and they do the evaluation. Every single time the person has been so ill, they've actually then been moved to a full pink slip and taken in for that examination. And at least in, I think all, but I might be off by one, have actually ended up in the hospital. And that's how they've ended up going through the process. But there is a way to do this so-called fifth criterion as an outpatient. So I want you to be aware of it. Some other counties have attempted this. I've not heard that it happens with any regularity. And that's actually the reason that we're looking at the law change, the 5122 changes. So here you go. Here's some of the rights. So remember, this is your law school portion of the class. The 14th Amendment has due process rights. Again, it's supposed to be equal protection, and so we have all of these rights, not dissimilar from a criminal type setup. So you're getting a lot of protections here to be able to make sure that your rights are protected at all stages, including after the hearing, reading the transcript, and even appealing it. Again, rare that these get appealed. I've seen it, but only because I've been around so many years in Ohio. It's pretty rare that somebody appeals a probate court opinion like that. So clear and convincing. I do want to give you another piece of law here just so you understand it. So there are three main burdens of proof in the court system. Any of you have watched Law and Order or Criminal Minds or any of those other things, it's beyond a reasonable doubt. So beyond a reasonable doubt for a criminal commitment that is being put into a prison in general. Sorry, let me decrease the sound of one of my dogs here. So the criminal commitment is considered, not in the law, there's no numbers, to be 90% certainty. You're 90% certain that this person committed the crime for which they've been charged, and that, of course, can be decided by a judge or a jury, depending on what process is selected for that particular person. You would not want, beyond a reasonable doubt, to be the level of the burden of proof needed to put somebody in a hospital, because we'd be looking at such levels of illness that undoubtedly they would have already made a suicide attempt or already harmed somebody, which usually means a support person, because they don't randomly go out and hurt people on the street. They hurt people that are around them. A family member or the mother is often the big target, unfortunately, and so forth. So the bottom of this three is called preponderance of the evidence. And that is considered to be about 51% certainty. Some say, using our symbol here, a feather on the scale of justice, just enough to tilt the scales or tip the scales. And so the net result is that you would not want to make it that easy to put somebody in the hospital. That used to be the case. If you go back to like 1950s, a husband could say, oh, my wife is acting out. And because of the way the laws were, she could literally be taken in against her will on his say-so, basically, and stuck in a hospital. So clearly a bad time for not having equal rights, equal protection, right? So we've fortunately fixed that. In 1979, the Addington versus Texas U.S. Supreme Court case, so it controls the whole country by precedent, that clear and convincing evidence became the standard. And that standard means about 75% certainty. Oh, by the way, preponderance of the evidence is the standard, that 51% for a malpractice trial, which is very scary. And you understand now why people get so nervous, because 51% is very subjective, versus the 49% the other direction. So but the 75% standard is used for other things, not only civil commitments. So, for example, termination of parental rights. You don't want to make it too easy to take away the father's rights and the mother's rights, but you also don't want to make it so hard that the kid is really traumatized before you're able to do that. So this balance is the reason for that clear and convincing evidence. So this covers that, as well as I've already said it. Here's a little bit more about that around treatment over objection. Same concept here, right? We don't want to make it too easy or too hard. And as I said, Ohio makes it pretty hard. We're very restrictive before we do treatment over objection. And for time's sake, I'm going to go faster. Here's what the forms look like, just to give you a sense. What are the things we want to know in Ohio before we allow treatment over objection? We want to make sure that he lacks insight, right? Doesn't recognize that he's ill, doesn't recognize the need for treatment. Are they able to take in the information about risks, benefits, side effects, and alternatives? No. Any religious beliefs? So there is a caveat that they can say, I don't want the medications because of religious reasons, if these others are yes. Right? You can't say that if you don't understand it. You can't just suddenly say I'm a what would be the one Scientologist and I don't want your meds if the person actually is up here on a yes, unless they're up here on a yes. And then, of course, ultimately, do they lack capacity, which is the legal way of saying they really aren't competent to make a rational decision about this, right? Here's an example of this actually from a chart. Obviously, I took all the PHA off, where they literally write this in the chart step by step, and then the recommendation. That's ideal. That's the best thing. I love to see that in the chart. Here's a way of doing the medications, right? We used to list, you have to check every medication you might want to give the patient. I actually personally changed that to, and we've actually just recently updated this. I think this is not the newer one. So we've listed all the medications in each of these categories because there's been a good, nice increase in valuable medications over the recent several years. But that way you can mark it up. And then the person's allowed to talk with you about what they don't want. Maybe they always get a dystonic reaction when they take Haldol. Well, write it down there. We're not going to give you Haldol, right? Work with the patient even at the level where they don't have full insight. Maybe they can tell you, and maybe your chart reflects, yeah, don't give this person Haldol, right? That kind of thing. So I will stop there to see what questions people may have.